Hey everybody, welcome to my live stream. Let me get my phone set up right so we're set up on TikTok and all the other places. This is a live video with immigration attorney Kate Lincon-Goldfinch. This is about the news that broke yesterday after the policy memo from U.S. Citizenship and Immigration Services. This policy memo, the number is 6020199. You will have seen it referred to in many different ways. Aaron Parnas did a video saying the end of green cards as we know it. It has been very sensationalized, very misunderstood, exaggerated. Of course, we don't know exactly how it's going to be applied. So some people might be right in their fears. And I can tell you that just in my videos, a few videos that I've done on this memo, I've gotten many comments from you guys, questions, concerns. We've gotten a ton of calls and emails from our clients about whether this applies to your cases. And so the purpose of this live video is to get straight with you guys and to answer all your questions, hopefully calm some of your worries. It is a big deal. It is a big, bad memo. I am not panicking. And the reason that I am not panicking is that this memo, if it is applied in the way that people are worrying about, if it is broadly applied to spouses of U.S. citizens, etc., it will directly and explicitly violate the statute in the way that Congress passed it. And it's not some vague reference. It's not some constitutional right violation about whether somebody actually had due process or reasonable search and seizure, or a lot of these things that can be up to interpretation based on someone's political leanings. In my opinion, this memo will directly and explicitly violate statute. And generally, when this comes before the court, this question of Congress passed a law that says this thing explicitly, and now the president has issued an executive order, a policy memo, whatever other type of policy, and this is in violation of the statute always wins. And this one is a clear-cut one. So I've had a lot of people say, understandably, very skeptical things about me saying, well, this is illegal. It's not going to stand. And naturally, a lot of people say, well, what about all the other illegal stuff that they're doing that has been allowed? And I think that's totally fair. And the difference to me here, and the reason that I'm more confident, is because there is explicit language from Congress that considered this very thing. This is not a vague reference. This is something that has been legislated within the past 30 years. It was 30 years ago. So let's get to the memo. The memo addresses what's called adjustment of status. An adjustment of status is when somebody applies for a green card inside the United States. And adjustment of status is, again, defined by Congress under INA Section 245A. And what it says is that when someone has entered the country legally and they're eligible to adjust status and get a green card, they may go forth and get it. And adjusting means they can apply for a green card inside the country without having to leave the country. And so the main way that this is done is through family-based relationships, usually through marriages to U.S. citizens or permanent residents, sometimes through being a child or a parent of a U.S. citizen is how this is done, this adjustment of status. Sometimes it's done through employment. Sometimes it's done through humanitarian cases, like you got an asylum grant, or you got a U visa grant, or you got VAWA, or you got a T visa, and now you're adjusting status. So what we're talking about is adjusting status and getting a green card in the United States. Now, there's another section of the law, 245C. So 245A is the definition of adjustments. 245C is all of the ineligible people. And within that section, there are exceptions to the exception. So, for example, immediate relatives of U.S. citizens are an exception. So let me give you an example of how this functions. Kate enters the country on a visa, whether it's a visa waiver or a tourist visa or a student visa, and she marries Josh, who is a U.S. citizen. But she marries him way after her visa expires. She's got all kinds of unlawful presence, it's called. Well, under the statute that Congress wrote in 1996, Kate is still eligible to adjust status, even though she had many years of unlawful presence. And the reason for this is that when they created the statute, they also created all of these bars for unlawful entry that mean when you leave the country, you can't get back in for 3 or 10 years. It was a whole new law that was passed in 1996 called, we refer to it as IRA, but it's the Illegal Immigration Reform and Immigrant Responsibility Act from 1996. So it created this whole new scheme of adjustment of status, consular processing, 3 and 10 year bars, et cetera. And so we've all been just operating under this statutory scheme for the last 30 years. What has happened with the Trump administration is they have decided, despite what they are messaging, they have decided that we don't like legal immigration systems and we want to limit the ways that people can immigrate legally. And one thing we really, really, really don't like are people who were paroled in under Biden. And there were lots of folks who got parole either out of detention or parole into the country under the Biden administration. And many of them got a particular type of parole, which is called 212D5 parole. I'm sorry to get so technical with you guys on this. I don't normally do all of this, but I know I've got a lot of informed followers who are following the specific thing. So I'm trying to give you some, statutes and, actual technicalities that are, technical information. So 212D5 is a type of parole that is considered an admission for purposes of adjustment. So there are plenty of folks who have gotten in or gotten out of detention on a 212D5 parole who then go on to marry U.S. citizens and they're eligible for green cards. And we know that Stephen Miller, the Trump administration, cannot stomach the idea of someone who came in under the Biden administration, especially if they were paroled in, now being eligible for a green card. So this memo explicitly talks about 212D5 parole and people in that category. I think that's primarily what they're after. But they also just vaguely talk about adjustment. And they say, you know what? This is actually something, this is an act of administrative grace that we give to someone. This is discretion. This is not just about statutory eligibility. And from now on, we're just issuing a blanket directive to our adjudicators that we want you guys to exercise your discretion. But of course, they don't say this qualifies, that doesn't qualify. And part of that, I think, is that they're trying to survive litigation because they're like, well, we're just, telling our officers to exercise discretion. Surely that's going to be one of their arguments when they get sued, which will also surely happen. But they are not saying like, if there's a fraud finding or a criminal history or 212D5 parole, that these are the people who are ineligible. They're just saying from now on, we think adjustment of status is an act of administrative grace, and we're only going to exercise it in extraordinary circumstances. So all the folks who are adjusting, who are already filed, this is a really common question. If you've already filed your application, it applies to you. If your case is pending, this memo applies to you. If you've already had your interview and you're waiting for the decision, this memo applies to you. It is retroactive. So everybody who has this case pending is like, what does this mean for me? This new vague reference to discretion and administrative grace. Well, we know what they also refer to, other than the 212D5 parole, is criminal history, visa overstays, immigrant intent. That's a big one. They really don't like it when people come in with a tourist visa and intend to apply for a green card. They haven't liked it for a long time, but now they're cracking down on that. Public charge issues. And then I think I already said it, but fraud is going to be another big one. So obviously people who have fraud findings or criminal history have already had to be careful. Now they're going to be digging in and I guess accusing more people of fraud. So we are going to be continuing to file these applications. The statute is clear about who is eligible to adjust status, and they cannot change that by memo. Okay, there's going to be a large lawsuit about this. There's going to be some type of impact litigation that's going to bring a lawsuit that's likely going to be a class action. And I think that the federal courts will say this is a very illegal thing. There's also going to be on an individual case level, a lot of cases are going to be slowed down. The decisions are going to be slowed down. You might be issued something called an RFE, a request for more evidence, or a NOID, a notice of intent to deny. These are going to be the things that people are going to start getting to sort of put gum in the works and slow down their adjudications. But when you have that, you can appeal, you can file a lawsuit under a mandamus. There are ways that we can fight back both at the systemic level and at the individual level. And you better believe that the immigration law community is ready to fight this stuff on behalf of our clients. So the net of the situation is it is broadly discussed in the memo. Therefore, it will be broadly applied by officers who don't have clear guidance. So this is what happens when you issue a vague directive to thousands of officers. They're all going to interpret it differently, and it's going to be different at different offices based on the supervisor, based on the officer. People are going to get different outcomes. So, for example, you might in the Seattle field office be able to adjust as the immediate relative without any problem of a United States citizen. But in the San Antonio field, and I'm just making this up, I don't know how these two offices are going to go. In the San Antonio field office, they might decide for a little while they're going to deny them until they get sued and they change course. So it's going to be a mishmash, chaos situation. My recommendation to everybody who is considering adjusting, about to file, you've already filed, you're going for your interview, you're waiting for a decision, is that you keep going. You keep filing. If you are eligible to adjust status, do not proactively decide to go the consular processing route. This is what they want you to do. They want you to decide, oh, I'm just going to go to the consulate. That's not good, because if you've been here with unlawful presence, you're going to trigger a bar. And you're not going to be able to get back in without a waiver, and you might be out for a while. So don't just go to consular process. I think this is going to be the most unfortunate outcome, is that some people who don't have a lawyer are going to just read some articles and decide to do the consular process because that's what this memo says to do. And you're going to really mess up your life, your future, and your family's ability to stay together. So definitely push forward on the adjustment. If you're eligible for the adjustment, do not give up on this. And I think my, crystal ball is that this is going to not actually be applied as broadly as the memo suggests, and that there will be a big lawsuit that will block it, and there will be individual lawsuits to force cases to move more quickly. I think at the end of the day, this policy change is not going to be as impactful as it sounds like it will be right now. That's my read on this thing. So let me start getting to your questions. Okay, here you go. Erica, hi. I'm nervous DACA won't be renewed anymore. DACA is completely separate from this. And in fact, I have heard there's some DACA advanced parole adjustments that are still getting approved even since this memo. So this is not DACA related. And DACA it's its own category of concern. We're waiting for the decision from Judge Haynen on what's going to happen in Texas. But they are renewing DACA. They're just slowing down. They've basically decided they're going to start doing more vetting on all of the cases. And so we're seeing a slowdown on all of our cases. But this memo is unrelated to DACA. Okay, DACA adjustment of status through a child over 21. So this is a specific carve-out category in INA 245C that says you're eligible to adjust status as an immediate relative of a U.S. citizen. So this is one where the statute is crystal clear that you are eligible to adjust. The memo is adverse to the statute, and it will not survive. One thing you can decide to do is submit some positive discretionary information in your application. So like we'll probably start doing this in my office, just a one-page sort of, this is why I didn't do consular process. This is why I warrant exercise of discretion. These are my positive equities. Like you might put all of that down on paper, but you definitely absolutely remain eligible to adjust status despite the threatening messaging of this memo. And so definitely file, definitely move forward and hire a lawyer to help guide you through the process. And if we have to sue them, we will. Chispa de Bomba, thanks for always being here. Does this memo affect the separate Cuban Adjustment Act adjustment of status applications? The memo doesn't specifically reference Cuban adjustment, but it talks vaguely about adjustment. And so I would say yes. And so similarly, Cuban adjustment, super eligible, very clear by statute. You might want to include some positive discretionary information. Don't go overboard. Don't, turn in 100 pages of evidence, but talk about your positive discretionary factors. Did you graduate from college? Do you have some professional license? Do you own a home? Do you pay taxes? Do you have kids here? Are they in school? Do you have elderly parents? Just quickly tell the story with a couple of pieces of evidence about why it's in your interest to be able to get your green card. And I almost hesitate to recommend this because it's not required under the statute. And so I don't want us to be going overboard here unnecessarily, but I'm also, a realist. And so if we want to just get a thing over the finish line with a particular officer, you might want to just hand them a little bit of something so that they've got their back covered on making a positive discretionary decision. If I applied via the Cuban adjustment to the green card and work permit, I think that this, similar question could similarly be affected because it's an adjustment. And so you might want to do positive discretionary factors. Okay. So I'm applying for EB3 as an RN. This is an employment-based category. This would affect your case, especially if you have had any unlawful presence. So if you're adjusting under Section 245K, that allows you to have up to 180 days of unlawful presence, this memo might affect you. And so positive discretionary factors, have a lawyer, sue them if they try to deny you. Could a psych eval help with these cases? I don't think so. I think that's overboard. If you have been going to a therapy and you have a tight relationship with your therapist and they're like, please, can I write a letter for you? And they're not going to charge you a bunch of extra money to do some eval. Sure, get a letter from them. But don't go pay $1,000 plus to go find a new mental health evaluator to do a bunch of sessions to get a write-up just for this. Only add that in as part of your positive discretion if it's easy for you, would be my advice. DM. This came through a DM. I applied for a green card, and keep them coming, guys. All the questions it really helps me know where your heads are at. And so keep them coming, DM, comments, etc. I applied for a green card through my U.S. citizen spouse. We had our interview this week. The I-130 was approved the next day. I had disclosed that I worked without authorization. I presume that in the past, I came to the U.S. with an F1. I'm still unlawful. That's good status. Right now, I'm waiting for the approval of the 485. Will this decision affect my application? So you're, first of all, eligible under the statute. They cannot change that with the memo. If they try to freaking deny you, then you will appeal and sue them. Okay. But you're in, I think, an even better category, or more protected, safer category, I should say. As someone on a student visa, you're still in valid status, meaning you've not overstayed, you've not violated the terms of your visa, you've not committed fraud, you've not done any of the things that they're listing. So I think you're probably in a good spot. And my guess, the reason that they've approved your I-130 but not your I-45 green card is just because this memo just dropped. And like, for example, we had one of our lawyers in an interview on Friday, and someone came into the interview and was like, don't approve any interviews on the spot to the adjudicator that he was in their office because of this new memo. Like, we have to all calibrate. So basically the workers at USCIS are as equally like, as we are, so they just hit pause on a lot of things, at least in San Antonio. So I could see how they would just outright approve the I-130 and give it a second on the 45. But again, there is no legal reason for them to deny a case like yours. And if they do issue a request for evidence, a NOID, or a denial, you need to respond quickly with an appeal, but then we can also file a lawsuit. So there's going to be impact litigators who are going to be looking for plaintiffs who can sign up. So you might want to sign on into a big lawsuit as a plaintiff, and then you can also bring your own individual lawsuit if you want to do that under a mandamus. But I don't think that they're going to probably deny yours. I think it'll just be delayed for a minute. But I'm guessing you already have a work permit, so hopefully you are okay. Is the first time green card? My husband already has the 2-year green card. How do we have to apply to change the conditions? No, this does not apply to removal of conditions on a green card or, renewal of a green card. Citizenship cases, we've gotten a lot of those questions. What if I already have my green card? It does not apply to you if you already have your green card. Do you recommend any green card VAWA holders to travel outside of the country right now? If you've already got your green card, don't worry about this memo. Don't worry about this memo if you already have your green card. And if you don't have any other concerns, travel, criminal issues, living outside the country, then you can travel internationally. This memo does not impact the ability of permanent residents to travel. Does it apply to asylum adjustment of status? Maybe. I mean, not explicitly. I think that they are going to get confused. CIS is going to get confused with this memo, and then we're going to see a lot of crazy stuff coming from all sorts of different places, and we're going to have to basically go into battle. That's what we're going to have to do. So I could see an asylum adjustment getting impacted, but it's not specifically on the list. Pending asylum applications not impacted by this memo. Is DACA affected if petitioned by a child over 21? Yes, but not because you're DACA, just because you're adjusting as an immediate relative of a U.S. citizen, but you fall into this category of clear statutory eligibility. This memo contradicts statute. Statute wins all day, every day. So I really feel, and I know confidence from me is not comforting for a lot of people. Like, yeah, well, we're not confident about anything. So why are you so confident? And it's true. I am an optimist, and I'm also a lawyer. I'm also a 20-year immigration lawyer. I also know that when a statute is right on point and it says something different than a presidential policy memo, the statute will win in court. And this isn't one of these was like, are we talking about the same thing? No, we're talking about the same thing. And so the statute will win. And the statute is in your favor. Is this retroactive for anybody? No, not citizens. It is retroactive in the sense that it applies to cases already filed. It doesn't apply to cases already approved for green cards, but it does appear to apply to already filed. Well, it does apply to already filed cases because it's impacting the interviews. How about K-1 visa to later adjust status? Probably not. This is a carve out in 245C. And so I think this is going to be, once the dust settles on this, they're going to have some clarity around which ones they just don't mess with. And a fiancé adjustment is going to be one of the ones that they just don't mess with. If they try to mess with you, you'll win once you fight them. If you came on a B2, married your boyfriend, but you're out of status 4 years when you filed, will they deny it? They might try. They cannot do that legally, and you will fight. So to prepare, go ahead and file, show up with positive discretionary factors at your interview, get ready to appeal or bring a lawsuit if they try to deny you. Don't let this change your course of action in that scenario, because you'll win ultimately. I have an interview scheduled. Is it going to be okay? Or maybe don't cancel. Do not cancel your interview. just do a little bit of prep. We might want to prepare, I don't know if you are our client or not, but we might want to prepare some positive discretionary information for you. Will my interview get canceled? Set for June 16th. Montgomery, Alabama, married to a U.S. citizen, overstayed, H-1B. I don't know. I don't think they're going to cancel it. They might deny you. They might delay you or try to deny you. It's good that you were on an H-1B. It's called a dual intent visa. So you can enter as a non-immigrant and intend to also apply for a green card. So you're not going to have intent or fraud issues related to that. So probably you're going to be okay. We'll have to watch these things over the next couple of weeks, and every office is going to be different. So like Montgomery is going to have a different attitude about this than other offices. But I feel pretty confident for you. Green card, 10-year-old renewal in the process of 2 months. What should I expect? No difference. Maybe delays unrelated to this memo because of the vetting that they're doing, background checks, but it's not going to affect you. Does not affect refugees. Will not affect refugees. What happens with people that have not overstayed their visa? Well, you're in a better position, but I don't want people who have overstayed the visa to freak out when you hear me say that, because you're still eligible. If you're eligible to adjust status, and you overstayed your visa, then you're eligible to adjust based on the statute. So, but people who have not overstayed might be in the category of ones that USCIS is like, oh, okay, we'll exercise our discretion for this person. That might be the position that they take. Why is FOIA taking so long? Same reason everything else takes so long. They don't prioritize our needs. Similarly, you might have to sue on FOIAs. I'm worried about my 5-year relationship as a Canadian TN holder. We were planning on filing, but now I'm afraid because my visa was non-dual intent to begin with. Where does this put me? Look, you've been in a TN for 5 years. It's perfectly reasonable at this point to say, like, you came in as a non-immigrant and you lived here for 5 years and you met and fell in love and you got married and now you want to stay. Like, that is not fraud. That's just called being human. So I would not worry for you. I would totally file your case, maybe fight if we have to. Hopefully you wouldn't even have to. How will this affect I-601A waivers that are under review? And then what happens now after they are approved? Our I-130 was approved, but the 485 was denied. Why was the 485 denied? DM me, would you, on that? Why was the 485 denied? Because the waiver, this memo doesn't talk about waivers, so maybe it wouldn't impact that, but I want to know why your 485 got denied. If you are out of status when you file, but will you get denied even if the statute says you are not barred? I mean, we don't know what they're going to do, but if you get denied, that is incorrect and illegal and you can appeal. So, I mean, here's the thing. I think, guys, I think our community might be overreacting a little bit. I mean, I can tell you that the lawyers are like, this is the biggest pile of bullshit ever, and there's no way we're going to let this fly. You know, like that's the conversation that the lawyers are having. The conversation that applicants and the immigrant community are having is like, oh my God, I've been waiting. I've been saving money. Now I can't get my green card. I'm going to get denied. That is not how the lawyers are feeling. We're like, okay, here we go. Like strapping on our boots. You know what I mean? So if you were out of status, could they try to deny you? Yes. And that would be a violation of the statute and we would sue and ultimately succeed, in my opinion. So EWI stands for entry without inspection, and this is somebody who did not enter with a visa, but generally is not going to be eligible to adjust status unless you entered under VAWA, or you're applying under VAWA for victims of violence, or you are a family member of military, or you qualify under a very old law, 245I. Then you're eligible. So mostly EWIs don't adjust anyway. Extraordinary, good question. It would be nice if they defined what extraordinary circumstances could be, wouldn't it? I just realized I'm not reading the questions out loud for TikTok, so I'll do better about that. So extraordinary circumstances would, I think, probably be what I'm talking about, positive discretionary factors. You've worked a long time in the United States. There's health issues. You are a person of good moral character, you own a home, you have a long time job, you pay taxes, that kind of stuff would be the extraordinary. It would really not be in your interest to leave the country to consular process. For F2A applicants, should we still try to AOS if going consular processing? At what stage is required to leave the U.S.? So F2A is a second category for family. That means you're the spouse or the minor child of a permanent resident. You're not an immediate relative of a U.S. citizen. You're not eligible to adjust unless you've been in legal status the whole time. So if you've been in legal status the whole time, go ahead and adjust. If you haven't, then you have to do consular processing, and you leave at the very end, right before you go out to get your green card. We're waiting on our visitor status approval. This is our third time applying. Any insight? So you're out of the country and you're applying for a tourist visa. It's really, really hard. Once they've denied you twice, it's really hard to get it a third time. I'm sorry to say. If overstaying a visa is the only issue that can trigger a rejection. No, they've talked about, okay, so anybody who entered on parole, fraud, receipt of public benefits, overstay, criminal history. These are the things that they don't like. And just as a reminder, if people just joined, I'm an immigration lawyer. I'm talking about the new USCIS policy memo saying that most adjustments will only be approved under extraordinary discretion, which has been translated in the public to mean green cards are over, which is not accurate. My boyfriend, any advice on those with interviews next week? Have a lawyer, prepare some positive discretion evidence, taxes, homeownership, kids, health issues, good moral character, job. What makes you a good and decent person that warrants an approval, which hasn't normally been something that you have to submit. My boyfriend got his H-2B visa approved for the second time. I'm a U.S. citizen. What can we do? Great. Congratulations. You can file for a green card once he's here. You'll have to look at the H-2B. Did he reveal that he was married to a U.S. citizen? If not, that could be considered fraud, and he might be one of the ones that's caught up in this and gets denied based on a fraud fine, or denied, or they would require a waiver. What about adjustment of status from an asylum seeker? Currently have a work permit, was in the process of adjusting status. I don't think they're going to include asylee adjustments. They don't say that they won't, but I don't think that they will. I think the most of the adjustments that are going to be caught up here are the employment-based adjustments and the family adjustments, not VAWA. Hi, Kate. EB3 process. We will apply for student status soon. How do you see this? Do you mean you are going for F1? And where are you? What status are you in right now? Tell me more. B2 overstay. Had interview already. I have military deferred action. Will this affect me? Potentially, yes. The military parole will help you because they like that. Let's just see what the outcome is. And then if you get an RFE, request for evidence, or a NOID, we can help you respond and ultimately sue them if we have to. If a friend came with a tourist visa, changed status to asylum seeker, now he's getting married to a U.S. citizen, is he in risk? I mean, he's included in this memo as the spouse of a U.S. citizen who is an immediate relative because he came on a tourist visa. But he's one that to me, that's an easy one. It's like, what's the discretion here? This person is an asylum seeker. They're not safe going back to their country. Of course, they shouldn't consular process. So I think you could draft an affidavit with a few pieces of evidence and overcome the discretion requirement for this one. Do you think this will affect EB5 after the whole economic benefit line? It's excluded from the statute that they reference, but a lot of this we don't know yet because we have to see how this plays out. But again, as a reminder, guys, this is going to be litigated. This memo is contradicting law. And so a lawsuit will be filed. Okay, I'm going to do 3 more questions, including this one. Okay. I changed from a B2, and then I'll be back on Tuesday and we can do as many more as you want. I changed from B2 to F1, and 3 years later, I filed the 485. Good. Case is pending, bios are done. OPT ends in July. And if I start another school, could that create any issue? No, I think that's great. You filed the 485 while your F was still valid. Doesn't look to me like you had unlawful presence. I think you're good and clean. You'd be someone that they would probably exempt from trying to deny you, would be my guess. My husband and I need to adjust status. My daughter is 21 U.S. citizens. Good. Do it. Call me. Don't delay. File your cases. Don't let this stop you. That's what they want. And we're not listening to them. Anything additional we can add to our application for the change of status, not out of stay, second visit, a year married, per this memo that would strengthen our case? Yeah, this would be the positive discretion. So here's why I warrant a positive discretion. I'm sick. My husband's sick. We have little kids. His parents live around the corner. I have a good job. He has a good job. We pay taxes. We're nice people. Like, basically, this is not, some sort of legal thing. This is like positive discretion, whatever that means. Meaning you're appealing to the officer who's sitting at the desk flipping through your paperwork. So putting together a good reason that they should approve you is what you'll do. Okay. 245I, this is the last one, and I'll answer this in Spanish. This is somebody who got status petition before 2001. You're explicitly allowed to have adjustment within the statute. They got to follow the law. And if not, they're going to get sued. 245I es elegible para ajustar estatus bajo la ley que el Congreso pasó. Entonces sí son elegibles, siguen elegible. So bottom line is, this sounds really bad and scary. It's complicated and misunderstood. The way that influencers are talking about it, the media is talking about it, is explosive and wrong and exaggerates the reality and is freaking everybody out. That's not to say it isn't important and it isn't going to impact cases. But the bottom line is, this is a memo that is attempting to change law that they can't change by memo. And this is going to be a lawsuit will be filed, and I'll put money on them losing the lawsuit because the statute is so crystal clear on this one. So as an immigrant or the spouse or family member of an immigrant, keep going. File your cases, move forward. Don't let this slow you down. Don't let this stop you. Hire a lawyer you trust, and just know that this will resolve. This will resolve through the courts. At a big level, there will be probably a class action lawsuit. I already know that there's some organizations looking at this. And then on the individual level, you can bring lawsuits as well. So March 4th, go get your green cards. Don't let this stop you. We got this. That's the message. So I'll be back on Tuesday, regular time, 9 a.m. Central, to answer more of your questions. Hang in there. It's going to be okay. We'll talk soon.